Oklahoma judges that covered by a criminal DA, you name it. I mean, all I wanted to do is just to have them go through my case, so I made it a little simple for them. Here's the charges. All right. Now we're even going to use the Oklahoma statute title itself. Now I want you to pause and back up and read some of this because I'm going kind of fast on here. Save time. There's the things. Now, even by Oklahoma statutes that I'm supposed to be charged on these things, we're going to actually go to the actual statute. Okay, this is Exhibit 2. This is to show you that it is. Now here it breaks down extortion to where, I'm threatening somebody, and here it is, larceny of trade secrets, and then it goes on to another section, what's larceny and what's grand larceny. Now here's the evidence. Okay, the state's evidence was an email I sent. Okay, if you look at it, there are no threats in it whatsoever, because here's the document on the brief appellant for my thing. And you can back this up and read it. I'm not threatening these people for anything or demanding anything. So it doesn't meet the criteria as extortion. Okay, it's simply just a statement. And the Oklahoma statute is written in everyday language to avoid misinterpretation. Okay, the property they were saying I was trying to steal was unemployment. OESC is the only one that authorizes it. The first filing and your first appeal is underneath labor law. The second appeal is court in case of wrongdoing. Now this is my unemployment case, and I found that when I sent back a copy, back up and read this, sent a copy of the on-site custody form, I noticed that it had been tampered with after I signed it. And here's my evidence that shows it. You'll notice here in the remarks, nothing. You'll notice on Simply Safe's remarks, this is where Marley Andale committed fraud. Okay, now this is my first appeal. I knew I wasn't going to win it, but the second one I would have won because I had a proof of tampering. Now the signed pre-assigned employment things, these are nothing. These are not an NDA and these are void and null upon termination. So I wasn't even working for this company for 2 months and they pulled this shit on me. Okay, now this, as far as the American Consumer Protection Act, this is public information right here. You can go to the thing. Now as far as all this training that John Richard Roy testified on, he was never there. So how can he testify on things he wasn't there? This is where it says, and the lease springs are no part of any kind of trade secret. And the $10,000 he mentioned was the license to manufacture the product. It has nothing to do with what the things are worth. You can call it Ford and they'll give you the dimensions. As far as John Richard Roy's testimony, since he never produced any paperwork on training or anything, or it wasn't even present. Now this is where they cover up for each other. Instead of looking at the initial problem, what I've been complaining about, they keep piling on bullshit after bullshit.